Let's take a look at a BFOQ defense. Employers that base employment decisions on protected class characteristics are engaging in disparate treatment. When they do so overtly and argue that it's necessary to limit a particular type of employment to people with specific protected class characteristics, this type of disparate treatment is termed a facially discriminatory policy or practice. It is not necessary to delve into the employer's motive in such cases because policy or practice is discriminatory on its face. An important, albeit limited, defense is available to employers that adopt facially discriminatory requirements. If an employer can show that a protected class characteristic is a bona fide occupational qualification, a BFOQ, for the job in question, the facially discriminatory requirement is legal. Employers must not establish protected class requirements for jobs except in rare instances where those protected class requirements are BFOQs for the job in question. But because racial discrimination was the central problem that motivated passage of the Civil Rights Act, Congress was unwilling to allow for any circumstances in which employment opportunity could be limited on the basis of race or color. Thus, the BFOQ defense is not available for policies that facially discriminate on the basis of race or color, and employers must not establish racial requirements for jobs. Although the term reasonably necessary does not sound overly exacting, the Equal Employment Opportunity Commission and the courts have made it clear that this is a narrow exception to the general rule prohibiting disparate treatment. It is important to distinguish disparate impact cases. In some neutral requirements, like employment tests with discriminatory effects, must be defended as job-related and consistent with business necessity. Alternatively, disparate treatment cases involve facially discriminatory policies in which specifications based on protected classes, like we want to hire female servers because that's what our customers want, must be defended as a BFOQ. These terms apply in different contexts and are not synonymous. A disparate impact claim can be defended if it's challenged as a requirement is associated with the job and job performance and appears reasonable given the nature of the business. In contrast, defense of a facially discriminatory policy requires that the employer show that only people with the specified protected class characteristic can do the job, and that that job is integral to the operation of the business. In other words, hiring people without the specified protected class characteristic would not lead simply to lower job performance, but would ultimately undermine the business. Arguments for BFOQs based on discriminatory preferences of customers, coworkers, or clients are usually unsuccessful. Otherwise, employers could shrink their responsibilities by blaming others. It really would like to hire a woman as a vice president, but our senior managers are old-fashioned and wouldn't be comfortable dealing with her. This would leave a gaping hole in anti-discrimination law. Given the narrowness of the BFOQ defense, when is it recognized? The courts have recognized three general grounds for establishing BFOQs: authenticity, public safety, and privacy. The classic example of authenticity or genuineness is a director casting a movie and limiting a female role to female actors. Authenticity also applies where sex or sex appeal is the essence of the job and the business. Owners of clubs featuring topless dancers need not consider males for those jobs. The more difficult cases involve jobs that contain both sex-linked and sex-neutral aspects. A BFOQ will be recognized if the sex-linked aspects clearly predominate. The second basis for establishing a BFOQ is public safety. When hiring or assigning employees with a particular protected class characteristic is necessary to protect the safety of others, fiscally discriminatory requirements are legally defensible. Although the ADEA generally prohibits mandatory retirement and other maximum age requirements, public safety concerns sometimes allow employers to consider only younger people for jobs. A BFOQ based on public safety was upheld for an inner city bus company that limited new hires to people younger than age 40. Before excluding older people from safety sensitive jobs, employers must establish that the risks posed are substantial, and more individualized means, like regular medical exams of identifying people who might pose risks, are not feasible. The third basis for a BFOQ is customer privacy. This consideration primarily relates to requirements for employees of a particular sex. One BFOQ case with a privacy basis concerned a psychiatric facility's rule that at least one person of each sex be available in each shift. Except when clear authenticity, public safety, or privacy interests are at stake, employers should not impose protected class requirements for employment based on the demands or needs of customers or coworkers. The best advice for BFOQs is that even when suitability for a job is associated with protected class characteristics, employers should seek more individualized means of assessing suitability rather than rely on protected class as a convenient proxy. Employers might be required to convince state fair employment practice agencies that BFOQs are warranted before putting them into effect. A less obvious form of facially discriminatory policy or practice occurs when neutral criteria are applied to some protected class groups but not others. In an important Supreme Court case, an employer refused to employ women with children younger than age 5. The company did not concern itself with ages of children for male employees. Even though the majority of the company's employees were women and the policy excluded only some women, it was deemed facially discriminatory because it limited the employment opportunities of women only. Likewise, a female truck driver could go to trial on her claim that the trucking company that she worked for required her to obtain an independent medical evaluation of a gynecological condition while not requiring the same for males with serious health conditions. Although circumstances may call for sex-specific requirements or policies, the general rule is that employers must not establish requirements that apply to some protected class groups but not others. These cases are labeled Sex Plus because they most often involve differential requirements based on sex, but the issue is really Protected Class Plus. Affirmative action often takes the form of good employment practice. These practices may be encouraging more diverse applicants, posting all employment opportunities, eliminating selection criteria that impose unnecessary barriers to employment, and offering development and mentoring opportunity. Measures such as these do not leave anyone worse off and raise no issue of discrimination. Federal contractors are limited to these measures and required to make selections in a non-discriminatory manner. Placement goals do not provide the contractor with a justification to extend a preference to any individual on the basis of that person's race, color, religion, or national origin. The difficulty with these affirmative action measures is they are not effective without strong commitment from employers, and any improvements they yield are not likely to be immediately seen. Employers sometimes go further and apply a preference for women or persons of color in hiring or promotion decisions in an effort to more rapidly achieve affirmative action goals. In such cases, the protected class characteristics of applicants or employees are considered in making employment decisions, and those decisions sometimes differ in what they would have in the absence of affirmative action. The use of preferences for women and people of color is the most controversial and legally problematic issue surrounding affirmative action. In reverse discrimination cases, an employee alleges disparate treatment. The claim is that an employment opportunity was lost because an employer with affirmative action plan considered the protected class characteristics of applicants and chose a less qualified woman or person of color. In these cases, the employer has, in fact, taken protected class into account to some extent, but argues that doing so was permissible because it put an affirmative action plan in place. The question is whether this use of affirmative action was discriminatory. In reaching an answer, courts will consider both the justification for affirmative action plan and the reasonableness of the particular measures used to implement it. Although affirmative action sometimes includes setting preferences based on race or sex, affirmative action is not a matter of establishing rigid quotas for persons with protected class characteristics, regardless of their qualifications. Loaded terms, such as quota, make it difficult to engage in objective analysis of the legal issues. The legal question surrounding affirmative action is not whether quotas are legal. The answer to that question is plainly no. The question is to what extent protected class characteristics can be considered for the purpose of undoing the effects of discrimination on women and persons of color. In Shea versus Carey, an appeals court considered a legal challenge to a voluntary affirmative action plan under Title VII. Its decision offers a thorough review of prior Supreme Court decisions in this area and exemplifies the close judicial scrutiny to which employer use of preferences is subjected. These are some of the basic requirements for affirmative action plans under Title VII. First, an employer that wants to consider protected class characteristics when making employment decisions to enhance the employment of women and persons of color can do so only if a formal, written affirmative action plan is in place. Professing a commitment to diversity is not sufficient. Affirmative action must also be remedial in nature. Although it is not necessary under Title VII to establish that the employer has discriminated prior to instituting affirmative action, the plan must address the manifest imbalance in the protected class composition of the employer's workforce. Put differently, the plan must be designed to remedy the underutilization of women and people of color rather than maintain a certain racial or gender balance in the workforce. Additionally, affirmative action is a temporary measure that must not continue after identified underutilization has been eliminated. The means used to pursue affirmative action goals must be moderate and not unduly burdensome on members of non-preferred groups. Specifically, affirmative action plans must not establish quotas, rigidly adhered to requirements such as a specified number or percentage of new hires that must be women, or set aside positions based on protected class. Efforts to achieve affirmative action goals must not result in hiring of unqualified persons. Likewise, affirmative action goals cannot be invoked as a basis for race or sex-conscious disciplinary or layoff decisions. More frequently, challenges to the use of preferences by public employers allege violations of the U.S. Constitution. In constitutional cases, courts subject the use of racial preference in affirmative action plans to strict scrutiny, the most stringent form of judicial review of government action. To survive a constitutional challenge to its affirmative action plan that uses racial preference, a public employer must show that the plan serves a compelling governmental interest and that the measures employed are narrowly tailored. Put differently, the plan must serve a very important public purpose and harm the interests of non-preferred persons no more than absolutely necessary. One compelling governmental interest is remedying the effects of prior discrimination by a particular public employer. Statistical disparities showing underutilization do not suffice as a constitutional justification for affirmative action, absent evidence that the public employer's discriminatory acts produced those disparities. A public employer that engages in affirmative action pursuant to a valid court order issued after a finding of discrimination would have a compelling interest in complying with the terms of that order. Courts scrutinize whether consent decrees actually require the specific actions taken in their name and whether they already outlived their usefulness at the time those actions were taken. In several cases, the Supreme Court has endorsed the view that non-remedial purpose, student body diversity, can be a compelling governmental interest that justifies the use of race in university admissions. However, the court has not provided any indication that this diversity rationale extends to the workforces of public employers. To be constitutional, racial preferences must also be narrowly tailored. This requirement is more likely to be met if racial preferences are not overly burdensome. Race-neutral methods were tried and proved inadequate. The preferences do not amount to rigid quotas, and their use is temporary. To say that race-conscious affirmative action plans can sometimes withstand the strict scrutiny required under the Constitution does not mean that states are required to use such measures. In fact, public employers in several states are prohibited from extending preferences in public employment, education, and contracting based on race and other protected class statuses. Research has shown that physical appearance has a pervasive effect on employment. People judged better looking are more likely to get hired, to be promoted, and even to be paid more. One aspect of appearance that can affect treatment in the workplace is weight. Research suggests that discrimination on the basis of weight is common and that such bias is particularly detrimental to women. Except for a very few jurisdictions, like Michigan, the cities of San Francisco and Santa Cruz, California, and Birmingham, as well as New York, weight is not a protected class. However, employers that discriminate against people because they're too heavy might be discriminating on the basis of disability. Courts have been reluctant to conclude that being overweight is a disability. Any chance of protection under diversity discrimination laws has depended on the individual being not merely overweight but morbidly obese. Most courts have also required that a physiological basis for the obesity or serious medical problems stemming from it must be shown. However, recent changes to the ADA have broadened the definition of disability, and several courts have subsequently found obese plaintiffs to be disabled without requiring evidence of an underlying physiological basis for the condition. Should an employer discriminate against someone deemed underweight, disability discrimination could be claimed if the person was anorexic or had some other disabling condition like cancer or AIDS as the cause of the person's thinness. Employer policies and practices that place differentially burdensome weight requirements on men and women can be challenged as sex plus discrimination. Employers impose many types of appearance and grooming requirements. Different rules are often established for men and women relating to such matters as hair length, facial hair, jewelry, and the wearing of dresses. Judicial discrimination to get involved in disputes over employers' appearance requirements can readily be discerned in case law. Nevertheless, courts also employ the logic of sex plus claims and ask whether differential requirements are truly more burdensome to people of one sex. In addition, courts are increasingly examining whether appearance requirements are rooted in demeaning sexual stereotypes. Courts are generally not receptive to claims based on differential appearance standards for men and women, but requirements for sex stereotypical standards are sometimes different. The U.S. Supreme Court made an important statement about sex stereotyping in a case involving a woman denied a partnership at an accounting firm. The comments of partners who participated in the decision process made it clear that they saw her as not sufficiently feminine. Partners criticized her for using profanity, being macho, overcompensating for being a woman, and being a somewhat masculine, hard-nosed manager. When informed that she was denied partnership, the woman was advised to walk more femininely, to talk more femininely, to dress more femininely, to wear makeup, have her hair styled, and wear jewelry. An even more sweeping application of sex stereotyping is found in the case of a transsexual firefighter diagnosed with gender identity disorder. The firefighter began to adapt a more feminine appearance, leading to negative comments from coworkers and efforts by managers to force him to quit, as well as his subsequent suspension. The court said that the crux of the case was the firefighter's gender nonconforming behavior and appearance. Regardless of the transsexual label, discrimination against an individual because he or she does not conform to stereotypes about how people assigned a particular sex at birth should act and dress does violate the Title VII of the Civil Rights Act. Nevertheless, courts have been far from unanimous in holding that sex stereotyping theory reaches discrimination against transgender persons. Application of the sex stereotyping theory to appearance requirements is a work in progress, and the results have thus far been inconsistent. The influence of appearance on employment decisions is perhaps inevitable. For some jobs, appearance is job related. Certainly, employers can establish appearance and grooming requirements that are all the same for employees. However, appearance is very closely intertwined with protected class. How will older people fare in a workplace beauty contest? What about people whose religious beliefs dictate a particular mode or appearance of dress? When grooming and appearance standards are needed, employers should ensure that requirements for men and women are not widely different, more burdensome on one sex, based on stereotypes, or likely to result in harassment. Appearance policies must also be flexible enough to allow for exceptions to accommodate religious practices of employees. The EEOC has highlighted the issue of discrimination against caregivers. Caregiver is not a protected class characteristic, but there are ways in which existing discrimination laws can be used to challenge employer practices that disadvantage caregivers. Besides childcare, caregiving includes the likes of caring for an aging parent or a disabled family member. Stereotypes about caregivers can dramatically affect both male and female employees. Female caregivers, on the other hand, may be perceived as less committed and competent at their jobs, regardless of the actual impact caregiving responsibilities have on their work. Males, on the other hand, may be regarded as ineffectual caregivers and denied leaves or other benefits routinely granted to women. In one important case, a school district denied tenure to a school psychologist with a young child. Upon her return from parental leave, she was questioned about how she planned on spacing her offspring. She began to receive criticisms of her job performance that contrasted with previous ratings of superior, and administrators questioned whether she would work a full day once she received tenure. More pointedly, administrators suggested that she reconsider whether she could be a mother and do this job, and flatly stated that it was not possible for her to be a good mother and have this job. The court found such statements to be sex stereotyping and evidence of discriminatory motive, even absent any evidence about how males with young children were treated by the school district. Employers that premise employment decisions on stereotypes of how caregiving responsibilities interact are engaging in disparate impact. It's not necessary in such cases to show that similarly situated persons of the opposite sex were treated more favorably. The law does not go so far as to require employers to be supportive of employees with weighty caregiving responsibility. Interviews are an almost universal aspect of hiring and promotion processes where the degree of subjectivity involved in assessing candidates tends to be high. Contrary to the urging of staffing experts, many employers persist in conducting unstructured interviews in which the questions asked, and even more so the criteria used to assess interview performance, are left to the interviewer whim. A systematic, structured interview process has both legal and practical benefits for employers. The ability to cite grounds for judgments about interview performance is critical. A candidate turned down for promotion to a management position partly on the basis of his poor interview that demonstrated a lack of aggressiveness did not prevail in his age discrimination suit. The court noted the importance of subjective assessments in selecting managers and professionals. It held that a subjective reason is a legally sufficient, legitimate, non-discriminatory reason if the defendant articulates a clear and reasonably specific factual basis upon which it based its subjective opinion. In one sex discrimination case, a court pointed to a mixed sex composition of an interview panel, the fact that all candidates were asked the same questions, and the scoring of the applicants' responses as relevant factors in ruling for the employer. However, the scoring of interviews does not, by itself, render them objective and non-discriminatory. The question is how the numbers were assigned. The ease in which bias can taint the interview process makes it advisable for employers to use multiple interviewers, preferably differing in race and sex. Employers should give substantial weight to impressions drawn from interviews only if they're specific and clearly grounded in statements or actions of job candidates. Interviews should be made as standard as possible by using structured interviews and scoring them according to a pre-established criteria. If impressions will be formed in this manner, then everyone should be at least given the same test. Interviewers should refrain from questions or comments pertaining to protected class characteristics. Verbatim written notes from interviews are not required, but the absence of any documentation produced at the time of interview makes it exceedingly difficult to provide specifics in a deposition a year or two later. Maintain written documentation of interviews, particularly observations relied on in making decisions about candidates. Employment can be offered in writing or verbally. To clearly state what's being offered and accepted, employers should put employment offers in writing. The offer letter should include the salary or wage associated with the position and the start date. It's usually in the interest of employers for employment to be at will. The offer of employment should specify whether employment is at will and is being offered, and explain in simple language what that means. The employment offer might reference an employee handbook or other materials as authoritative sources about the terms of the employment relationship. In any event, the offer should clearly specify what is included in the terms of employment and indicate that no further commitments have been made. If an offer of employment is conditional, for example, upon a medical exam or acceptance of the offer within a specified period, the condition should be clearly stated. Most new hires are employed at will. Courts treat employment at will relationships as contractual, but a contract to employ at will amounts to nothing more than a promise to pay a specified wage for work actually performed. Because either party remains free to terminate the employment relationship at any time, there's no breach of contract if the person is hired but not given a chance to commence employment. A stronger legal claim is available in this situation. Courts recognize claims for promissory estoppel in situations where injustice would otherwise occur because a person has reasonably relied to her detriment on the promises of another. The basis for the claim is not a contract, but rather the harm that occurs from reasonably relying on another's promise that there would be a contractual relationship. When applied to the withdrawal of a job offer, it could be argued that the employer's offer is an unambiguous promise to employ on which the new hire reasonably relies by doing such things as relocating and turning down alternative job offers. If these reasonable actions result in harm, a promissory estoppel claim can provide a remedy. Some courts have accepted this view. There are lines of progression in work organizations such that promotions usually occur out of particular positions. If the effect of initial hiring decisions is to segregate some groups into dead-end jobs from which promotions are not typically made, that effect will also manifest itself in future promotional decisions. The process for making promotions is often far more informal and covert than it is used for initial hiring decisions. Posting for positions and establishment of formal application and candidate review processes might not occur. Informality and lack of transparency lend themselves to discrimination, or at least the appearance of it. Potential candidates for promotions might not learn about the existence of these employment opportunities until after the fact, when the winner is announced. Another distinctive aspect of promotions is that employers have a great deal to do with determining which individuals possess the qualifications needed for promotion. Unlike external hires, promotional candidates acquire many of their qualifications through their employers' training and development programs, job assignments, intentional or international opportunities, and mentoring. Not all employees have equal access to these qualification-enhancing opportunities. This is intensified by the flattening of corporate structures in recent years, which has resulted in fewer promotional opportunities. Despite evidence that they are not very proficient at doing so, companies regularly attempt to identify high-potential personnel, both managerial and technical, who receive more access to development opportunity. These judgments, which are sometimes spelled out in formal succession plans, are then reflected in who is prepared and selected for promotion. The Department of Labor defines glass ceilings as artificial barriers based on organizational bias that prevent qualified individuals from advancing into upper management positions. Glass ceiling is not a specific type of legal claim, but the term does succinctly capture the experiences of many highly qualified women and people of color. Such circumstances have prompted lawsuits alleging a pattern or practice of discrimination, disparate impact, or other claims. Advancing to higher level positions in elite institutions is a rugged, competitive process. Lack of advancement does not necessarily reflect the workings of unfair, discriminatory obstacles. To the extent that such obstacles exist, the measures needed to deal with them go beyond the general advice for promotions. Employers should closely monitor the career progress of women and people of color. Evidence of disproportionate lack of advancement should prompt a wide-ranging self-analysis. Employers should examine the protected class composition of positions from which promotions are made and the manner in which key projects and other developmental opportunities are assigned. Because many promotions rest on previous positions and project assignments, it's also important that women and people of color get into the pipeline and have access to important positions and developmental experiences. Employers should provide management development programs, assistance in career planning, and mentoring. Mentors provide less senior professionals with the benefit of experience, coaching on career choices, and visibility in higher organizational circles. Other important steps involve removing impediments to performance, including harassment and aspects of an organization's culture that might be hostile to protected class groups, like emphasis on off the job socializing. Turnover patterns should be carefully examined, and they might indicate frustration with the lack of advancement or responses to harassment. Flexibility in considering less traditional career paths and backgrounds in promotional candidates opens up opportunities and increases the number of qualified women and people of color in the pipeline. A more diverse pool of qualified external candidates for management positions might be obtained by considering people who have proven their leadership ability in nonprofit organizations, the public sector, universities, and the military. These practices, needed to deal effectively with glass ceilings, take an employer well beyond the minimum requirements of anti-discrimination laws and in the direction of affirmative action.